Live. I want you to test for me that we're live and that we can hear things.
Where would I find the link? On Facebook?
Yeah, it's our YouTube. I'll give it to you here. It's if you go to YouTube, you can actually just Google us, but what? I'm not on mute.
No.
Hi, guys. Make sure that we can hear Judge Donald.
Okay, testing 1, 2, 3.
All right. Petitioner? This is sounded ready. All right. Is your comment ready?
Yes, Your Honor.
All right. Petitioner? I'm going to be breaking you and your co-counsel going to be dividing issues or arguments.
Yes, Your Honor. I'll be addressing the first issue, Mr. Wall will be addressing the second.
And the first issue.
Yes, the question of jurisdiction.
All right. Please proceed.
Mr. Chief Justice, and may it please the court. My name is Lawson Hamilton, and my co-counsel J.C. Dubois and I represent the petitioner in this case, Keegan Mason. Your Honors, at this time, I'd like to reserve 2 minutes for rebuttal.
No.
Your Honors, one housekeeping matter. Because of an eye condition, it often appears that I'm looking down even when my head is up. So unless I'm pointing my head directly down, I am attempting to make eye contact.
All right.
Your Honors, there are 2 issues before the court today, and I'll be addressing the first, which is why the first to file rule of the False Claims Act is not jurisdictional. My co-counsel, Mr. Bois, will address the second issue, which is why a medical opinion does not have to be objectively false and fraudulent under the False Claims Act. Your Honors, this case is about following the text of the False Claims Act where it leads, to ensure that courts possess the power to stop frauds against the government while discouraging races to the courthouse that might foreclose better claims brought at a later time. Accordingly, we ask this court today to reverse the 15th Court of Appeals for 3 reasons. First, under this court's precedent, the first to file rule is non-jurisdictional because it lacks a clear statement of jurisdiction. Second, even if the first to file rule is jurisdictional, Mason's claim is not preempted because the earlier filed claim in this case was dismissed as legally insufficient under Rule 9b. And finally, even if this court rejects the notion that FCA claims must be pleaded with particularity under Rule 9b, Mason's claim is still not preempted because she alleges different essential facts. Your Honors, as I turn to my first argument, it's important to keep in mind that the respondent's case really hangs on this critical question of jurisdiction. As this court knows, if subject matter jurisdiction does not exist at the time of filing, it cannot magically appear at a later time. And so
Mr. Hamilton, let me just ask you, You say that there's no statement of jurisdictional in that is manifestly stated. Are you arguing that there must be a tag, a label that explicitly says jurisdiction, or can it be stated in ways that does not magically include the label?
Justice Donald, a statute does not necessarily have to include the word jurisdiction, but under this court's precedent in Argyle versus Y&H Corporation, it must include a clear statement of jurisdiction. And unless Congress includes such a clear statement, courts must presume that the rule is non-jurisdictional.
Excuse me, why does it matter? What difference does it make?
Your Honor, it matters because if the first to file rule is jurisdictional, then because there was a pending claim at the time that our client filed her claim, if those claims were related, that would require the dismissal of our claim. However, if the rule is non-jurisdictional, as we contend, then the fact that the earlier filed complaint was dismissed as legally insufficient under 9b renders the first to file rule inapplicable to this case. And that's why the jurisdictional question matters in this case.
Well, does it matter whether in the case of two filings involving the same subject matter, does it matter whether the first one filed is still pending at the time of the second filing, or does it have to have been dismissed before the second is filed? In other words, can it be concurrent, or if there's a consecutive filing after one's been dismissed, does that change anything?
Your Honor, this court in Kellogg versus Brown and Root Services held that if a previously filed complaint is dismissed, nothing prevents a new relator from bringing a new claim, even on related facts. However, if as in this case, which represents a unique factual situation, which this court has not yet accounted for, that the first filed claim was pending while the second filed claim was brought, this court has not ruled on whether that second filed claim must be dismissed. Your Honors, our contention is that it should not be. Your Honors.
Did you investigate the first claim of Dr. Cobb?
Yes, Your Honor. If we look to the record at page 21, we'll see that the court, the government rather, did investigate Dr. Cobb's complaint. But Your Honor, whether or not the government chooses to investigate is not dispositive in this case, because the critical question is whether the government had noticed. What it did after that is its own prerogative.
Okay, well, I want to just go back and ask one final question, and then I'll leave this be. The language you just quoted was, if a case from our precedents, if a previously filed case has been dismissed, there's nothing to prevent a second one from being filed. Logically, can't we assume that if it has not been dismissed, then the second one is barred? Is that the kind of thing we can look at to make that call? And doesn't that speak to jurisdiction?
Your Honor, in fact, it does not. If we would look at the First Circuit case of U.S. versus Millennium Labs, that was one of the circuit courts that had previously held that the first to file rule is jurisdictional. But in light of this court's precedent from Kellogg and Argyle, it found that it had to reverse its own prior precedent and find that the rule is non-jurisdictional. And one of its primary reasons for doing so was that this court's treatment of the first to file rule in Kellogg suggested a non-jurisdictional rule.
Thank you.
What's the purpose of first to file to begin with?
Your Honors, the first to file rule serves the purpose to counteract the financial incentive that the key PAM provision of the False Claims Act brings to bring claims. It counteracts that by ensuring that not that many claims can be brought. Your Honors, Congress intended.
What's the appropriate legal standard for determining whether the petitioner's claim and the claim from Cobb's are related to each other, or whether they're distinct? In other words, they both involve the same party. They both involve allegations of Medicare fraud. They both specifically involve this individual, Dr. O'Keefe. So what's the standard for determining whether the claims are related or not?
Your Honor, the proper standard is the essential facts test. which, as the First Circuit noted in Duxbury versus Ortho Biotech Products, is the test that every circuit court in recent years has used to evaluate that standard, including the district court in this case, which the 15th Circuit affirmed. Your Honors, under that standard, unless the previously filed complaint contains all the same essential facts as the later filed complaint, then that second filed complaint is not jurisdictionally barred. Your Honors, if we look to the text of the first to file rule, we see that it does not bar all related claims, but only those claims that are based on the same essential facts as the
I'm
pending.
sorry. I may perhaps have missed, you may have said the standard of review for essential fact issue is what?
Well, Your Honor, essential facts is the test for whether claims are related under the FCA. But because this is a legal question, the standard of review is de novo. Your Honors, a lesser fraud.
I'm sympathetic to the notion that this might be a strangely drafted statute, but Congress has the power to set jurisdiction over controversies for our district courts. And Congress says you only have jurisdiction when you're the first to file. You don't have jurisdiction when you're not. How do we as judges get to ignore the directives of the Congress, even if we think that the directives of the Congress don't make a lot of sense and aren't consistent with the way we would normally grapple with jurisdictional issues?
Your Honor, Congress hasn't, Your Honor, you're right, that courts must follow what Congress sets as the jurisdictional limits of a statute. But in this case, Congress has not included jurisdictional terms within the first to file rule. And so under this court's precedent in Buchanan versus Holder, it's non-jurisdictional. In that case, this court held that where Congress includes particular language in one provision of an act, but excludes it in another, that disparate inclusion and exclusion must be interpreted as intentional. Your Honors, other provisions of the FCA do speak directly to jurisdiction. For instance, 3730E1 and 2 limit the first to file rule in terms of cases brought against members of the armed services and members of Congress. But they omitted such language from the first to file rule itself, which is further evidence that that rule is non-jurisdictional. Your Honors, moving to my second point, even if the first to file rule is jurisdictional, Mason's claim is not preempted because Dr. Cobb's previously filed complaint was dismissed as legally insufficient under Rule 9b. Your Honors, 9b requires that in alleging fraud or mistake, a party must state with particularity the circumstances constituting fraud or mistake. And Your Honors, because all FCA claims necessarily plead fraud, it's simply analytic. The FCA plaintiffs must satisfy Rule 9b. And this
But
court.
can't the complaint put the government on notice of potential fraud, even if it doesn't meet the heightened standard under Rule 9b?
Your Honor, there is a circuit split as to this issue. The DC Circuit in Baptiste versus SLN Corporation held that a legally insufficient claim may still put the government on notice, but the Sixth Circuit noted in Walburn versus Lockheed Martin that a claim which cannot meet 9b's particularity standard fails to provide the essential facts of a fraudulent scheme and therefore would not enable the government to uncover related frauds. Your Honors, the Sixth Circuit is the better standard because what 9b requires, or the purpose of 9b, is to put defendants on fair notice of petitioners' claims against them and their factual grounds. If Dr. Cobb's complaint could not do even that for Sam Clinics, it cannot have put the government on notice to investigate. Your Honors, turning to my final point, even if you find that the first to file rule is jurisdictional, even if you find that a complaint dismissed under 9b may bar later filed complaints, Mason's claim survives nevertheless because she states different essential facts. Your Honors, to compare, in Duxbury versus Ortho Biotech Products, two successive relators alleged that the maker of an anemia medication had used an off-label dosing scheme to promote physicians using this medication in impermissible ways and increase their Medicare reimbursements as a result. The only crucial difference between the first and second complaints was that the second pleaded its allegations in significant detail. The First Circuit held that that was sufficient for the second complaint to include different essential facts.
But
Your Honor.
here, it doesn't seem like there are different facts, it just seems like there's just added details to what appears to be Medicaid, defrauding Medicare.
Your Honor, the different essential facts is that if we look to the record of pages 6 through 8, we see that Mason pleads a far broader scheme of fraud than Dr. Cobb because she alleges that physicians at Sam clinics and multiple clinics involving a different treatment that Dr. Cobb alleges were receiving a financial kickback for submitting those false allegations. That is not a claim that Dr. Cobb's complaint encompassed, because Dr. Cobb's complaint, as we can see from the record at pages 5 through 6, alleges only one discrete instance in which a false certification of medical necessity was submitted for a surgical debridement.
So, counsel, is it your position then that the subsequent filer is not barred as long as they can beef up the complaint with some additional allegations and some additional details that's not present in the first complaint? Is that what you're contending the standard?
No, Your Honor, there must be a difference of more than somewhat different details. But Your Honor, our contention is here that Mason has pleaded a difference of essential facts because Dr. Cobb's complaint did not encompass that more far-ranging scheme that Ms. Mason alleges. Your Honors, it is for these reasons that I see another time.
Thank you, counsel. All right, we proceed.
Mr. Chief Justice, and may it please the court. My name is J.C. Dubois, and as my co-counsel, Mr. Hamilton, said, I will be addressing the second issue before the court today, which is why a medical opinion does not have to be objectively false under the False Claims Act. Respondent asks this court to ignore its own precedent when it comes to defining fraud. And if this court obliges, it will open up an enormous loophole for medical professionals to defraud the government. This court should reject that approach for 3 reasons. First, the text of the False Claims Act is silent as to the definition of false, meaning that Congress intended for the common law definition to be used. Second, petitioner pleaded a viable claim under the common law standard. And finally, even under the objective falsehood standard, petitioner presented sufficient facts and circumstances in order to plead a viable claim. Your Honors, before I begin my argument, it's important for us to understand the difference between the objective falsehood standard and the common law approach to falsity. Under the common law approach, a subjective opinion may be considered false if it is not honestly held or it implies the existence of facts that do not exist. The objective falsehood standard, however, incorrectly conflates the False Claims Act scienter and materiality elements with falsity, requiring only objectively verifiable facts during the pleading stage. And Your Honors, that brings me to my first point, which is that the text of the False Claims Act is silent as to the definition of falsity, meaning that Congress intended for the common law definition to be used. If we look to the history of the False Claims Act, it was first enacted during the Civil War era in order to prevent profiteers from defrauding the Union Army. It's been amended many times since then, but most notably in 1986, Congress amended the FCA by eliminating the element requiring a specific intent to defraud with only a knowing submission of fraudulent conduct. Further, this court held in Universal Health Services versus United States ex rel Escobar in 2016 that courts should not create a circumscribed view of the False Claims Act in order to preserve Congress's intent to reach all types of fraud. This court also explained that whenever a statute is silent as to the definition of false, that means that Congress intended for the common law definition to be used. And finally, the
And then,
court,
excuse me,
Yes, ma'am.
a medical opinion can be unreasonable, but does that make it false?
under the False Claims Act, that position would still be protected and it would not be considered false. Because the False Claims Act also has a scienter and materiality requirements written into the statute. So the scienter requirement under the False Claims Act necessarily protects physicians, but because it requires for a plaintiff to prove that a physician did not subjectively believe in his own opinion at the time of certification. And so even if a physician's medical certification was unreasonable, if he honestly believed in that certification at the time of diagnosis, then he still would not be liable under the False Claims Act.
Counsel,
And when we're looking to determine whether or not that standard, or that belief rather is unreasonable, are we looking at the prevailing views and determinations of the profession? Or what are we using to make that determination? Because you've said that if the statute is silent, we go back to the common law definition. So what are we looking at?
Your Honor, so we're looking to the facts that the plaintiff pleads in their complaint and whether or not they are plausible in line with this court's holding in Iqbal. And so essentially it is just required for a plaintiff to prove that there are plausible, under the False Claims Act, that it is plausible allegations that in this case that physicians knowingly submitted material claims to the government.
But you acknowledge, don't you, that the fact that other physicians may hold a different view is not dispositive of whether or not this is unreasonable or whether or not it's false, correct?
Yes, Your Honor, I would concede to that.
So there's got to be something more. And I guess what I'm asking you about is, from an evidentiary standpoint, what is the more that we're looking at? Because people can have honestly held beliefs that the prevailing community say are patently unreasonable.
Yes, Your Honor. And so essentially, I want to remind the court that in this case, we are still at the pleading stage. And so petitioner only needs to plead plausible allegations in order to survive dismissal. And if we look to the Third Circuit's decision in United States, X-Rel Druding versus Care Alternatives, that court reasoned that a mere difference of medical opinion, or not a mere difference, but a difference in medical opinion may be sufficient at the pleading stage. If it is enough to create a jury question, then it is enough to survive dismissal. And Your Honors, going back to the elements of the False Claims Act, which are codified at 31 U.S.C. Section 3729, the requirements to bring a claim under the False Claims Act are a false statement or fraudulent course of conduct made with scienter that was material and that required or caused the government to pay out money or forfeit monies due. Your Honors, the element in this case at issue is the falsity element. However, Congress already put into place a heightened pleading standard under the False Claims Act that makes it different from your run-of-the-mill fraud case.
Counsel, I'm a little bit confused about a couple things on this issue. One is that, as I understand the facts, CMS has very specific guidelines about which class of Wagner's injuries are eligible for hyperbaric oxygen treatment. Is that correct?
Yes, Your Honor.
Okay. And the standards with respect to which categories are eligible for treatment is an objective standard, correct?
Yes, Your Honor.
Okay. So either a physician complied with that standard or they didn't. Is that right?
That's correct. Yes, Your Honor.
So how does that fit in with the scienter? Does the physician have to know that he or she was, let's say, certifying as a class 3, something that was only a class 2? How does the scienter piece fit into the question?
Yes, Your Honor. And so, since the CMS requirements for HBO therapy are fairly objective, in this case, if in a complaint, it was demonstrated, as it was here, that physicians did not certify patients based on those objective requirements, there could be plausible allegation that that physician did not subjectively believe in his or her own certification. However, that would become an issue for discovery and a fact issue for the jury to decide at trial. However, but under the False Claims Act, it is required for it to be a knowing submission rather than a physician just making a mistake in diagnosing a patient.
So will we just get, I'm sorry, go ahead.
Counsel, in your allegations, client's allegations, she alleges that the medical records are actually changed. They're moved from being accurate to inaccurate. Isn't that enough falsity? Why do you want to take on this burden do we need to reach the question of the standard of falsity? Or can we merely just say, there's enough in your complaint, in this complaint, and as a secondary question, doesn't the Congress, didn't they really want it to be difficult for these cases to get to the courts? They wanted them to reach very high, very clear standards, so we're not flooded with them.
So, Your Honor, as to your first point, our contention is that the heightened objective falsehood standard should not be adopted by this court, and we should stay in line with the common law standard. As to your second question, Congress's intent under the False Claims Act is to, as this court explained in Universal Health Services, reach all types of fraud. And additionally, even if the falsity requirement is a lower hurdle for plaintiffs to overcome, they still have to plead the scienter and materiality requirements in the plain language of the False Claims Act. And Your Honors, that brings me to my next point, which is that the petitioner pleaded a viable claim under the common law standard. In United States Extra Winter versus Gardens Regional Hospital and Medical Center, the court adopted the common law standard and emphasized that a subjective opinion may be false if it is not honestly held. However, the plaintiff must still allege with particularity, scienter, and materiality. And in this case, Ms. Mason has alleged that these physicians knowingly made material submissions to the government in order to get them to pay out money. If we look to the record at page 2, Sam's Clinics receives 75% of its revenue from Medicare. Not only that, but once O'Keefe became CEO, there was a spike in HBO therapy. Further, if we look to the record at page 7, Ms. Mason alleges 4 specific patients in which they were certified for HBO therapy, even though it was not medically necessary. And all of these facts taken together, and as true under this court standard, demonstrates that these were knowing submissions.
Was there a particular doctor tied to any of those?
No, Your Honor. In the record, there is no specific physician mentioned. However, the one actor that is consistent in all of these allegations is O'Keefe, who is the CEO of Sam's Clinics, and then also all of these certifications were made by Sam's Clinics physicians. Not only were these allegations knowing, but they were also material to the government's willingness to pay out monies. If we look back to the record at page 7 at the 4 different patients alleged, most notably patient D had type 1 diabetes, and he was classified as a Wagner grade 3, even though he had no sign of myelitis, abscess, or osteomyelitis, which are all objective requirements under the CMS guidelines. Your Honors, and finally, to my final point, even under the objective falsity standard, the petitioner presented sufficient facts and circumstances to plead a viable claim. The holding in AseraCare, which adopted the objective falsehood standard, created 3 specific scenarios in which a medical opinion may be considered false under the False Claims Act. Those three scenarios included a physician certifies a diagnosis without looking at the patient's chart. Two, the physician did not subjectively believe in her own diagnosis at the time of certification. And finally, the third scenario is that no reasonable physician would have come to the same diagnosis. Your Honors, this is a case where the physicians at Sam's clinics did not subjectively believe in their own diagnoses. If we look to the quote, there was an alleged quota system in place, which is evidenced at the record at page 5. Not only that, but there was
What does page 5, what does it say?
on the quota scheme, it says that the higher ups at Sam's clinics were pushing physicians in order to meet a certain quota of HBO therapy. And not only that, you can also see on the record at page 5 that there was a conversation between Dr. Drake and O'Keefe discussing the illegal kickback scheme, in which Dr. Drake was talking about how he was going to be able to make a new down payment on his Tesla because they had certified enough HBO therapies. And so, Your Honors, it is for these reasons that we ask this court to reverse the 15th Circuit Court of Appeals.
Thank you. 2 minutes. 2 minutes. Now, okay.
Chief Justice, may it please the court. My name is Leslie Veloz, and I, alongside my co-counsel, Brian Hom, represent Southern American Metropolitan Clinics, Inc. The first issue before this court concerns the 15th Circuit's decision that the False Claims Act first to file rule is a jurisdictional bar to petitioner's complaint. That decision should be affirmed for the following 2 reasons. First, Congress's intent dictates that the first to file rule is jurisdictional. Second, the overlap of the factual narratives to the first filed case triggers a jurisdictional bar. The False Claims Act is the primary statute used by the federal government to police fraud in government programs. Congress intended this rule to prevent repetitive claims, to stop frivolous and duplicative litigation. To stop duplicative litigation, Congress created the first to file rule, which effectively prohibits any party other than the government from filing an FCA action based on the same essential facts as an earlier filed case.
But if the first filed complaint fails to plausibly plead a fraud claim, how do we say notice is met?
Your Honor, for the purposes of the first to file rule, it is irrelevant whether or not a case is dismissed or whether it meets the heightened 9B standard. Congress was clear in the first to file rule, which states that when a person brings an action under this subsection, no person other than the government may intervene or bring a related action based on the facts underlying the pending action. Petitioner urges this court to look at R-Bar versus Y&H Corporation. This case that was decided in 2006 was based on sexual harassment and of Title VII. This court should rely on the correct standard, which was decided 9 years later in this court in Kellogg Brown and Moot Services, which did create a bright line rule, which states that if an action is already pending based on the same facts, then the later filed case must be dismissed.
So counsel.
So counsel, I'm sorry. Well, counsel, is it your argument that it is really the subject matter or the general description of the case that governs? For example, if one case is filed about this Medicare fraud, even if it alleges, makes de minimis allegations, no other claim can be filed that sets forth the detail and specificity of the fraud and survive the first file rule, if you understand what I'm asking.
Yes, Your
I guess
Honor.
I want to know how much is enough?
Your Honor, Rule B5 is clear. It sets forth 2 steps, which was affirmed again in the 10th Circuit by Donna Little and Karash, which states that first, whether a case was pending at the time a later claim is filed, and second, whether they share the same essential facts, which brings me to my second point.
Just to interrupt you just a bit, because it feels like that would just encourage placeholder filings, right? Just, in situations where people actually know very little about whether fraud is occurring, but they just, are opportunistic and just, I'm gonna file it right now, just to prevent anything else from happening subsequently.
No, Your Honor, Rule B5 doesn't serve that purpose. Here, it only bars a second case if it shares the same essential facts. In this case, Dr. Cobb filed her complaint on October 14, 2019, as seen on page 5 of the record. Subsequently, Mason filed her complaint on November 22nd, 2019, as seen on page 1 of the record. Both claims are only 1 month apart.
But they are essentially different, right? The facts are different.
No, Your Honor.
One is about Dr. Cobb and what she felt like she couldn't do, and the other is about a series of other events that are beyond this one clinic, but expands to four others.
No, Your Honor. Both complaints are not that different. Both complaints arise from the same transaction or occurrence. They are both only 1 month apart. Both claims allege that Sam Clinics was reporting Medicare fraud. Both claims are located in Washington City. Both claims allege John O'Keefe as the CEO.
So counsel, let me just interrupt you a second, because I'd like to ask you kind of a hypothetical to help flesh this out a little bit about the same facts. Is it your position that if there's an allegation of Medicare fraud by a particular institution specifically relating to Medicare, that forecloses anybody else from making another allegation of fraud, even if, but let me give you an example. If we have an allegation of Medicare fraud involving fraudulent submissions for performing colonoscopies, and then later we hear that there's fraudulent submission in the screening for angiography. Those two things have nothing to do with each other, although they're both the same party and they're both Medicare fraud. In that situation, if there was a complaint alleging colonoscopy fraud, would that bar later complaint about cardiology procedures in your view?
Your Honor, to answer your second question, if the two procedures are completely different and they have completely different parties and they are not factually related, then the first of all rule would not bar that case. However, in this case, that is not the circumstance. To answer your first question, in this case, we have the same transaction or occurrence. They both allege the same clinic under the same CEO during the same time frame, and they have the same population.
But it's different treatment.
Yes, Your Honor. However, there's enough overlap between the two treatments that, as the 15th Circuit correctly held on page 23 of the record, that if the government was to investigate Dr. Cobb's action, it would have alerted them to the broader scheme. In this case, Mason's complaint is alleging HBO therapy fraud, while Dr. Cobb's claim is alleging surgical debridement fraud. HBO therapy is only used as a last resort after other treatments have been used. There are circumstances where debridement is done first and then HBO therapy is done second. Both procedures have the same patient population of being diabetic patients. Furthermore, the first of all rule does not bar complaints that are factually different. This court has set that bright line rule of if an earlier action is still pending, then the later action is barred. In this case, it is undisputed that Dr. Cobb's complaint was pending at the time that Mason filed her complaint.
what's the purpose of this statute? And how does that purpose advance if a poorly worded plea is dismissed? There's no resolution on the merits of the underlying allegations of fraud. How is the statute's purpose advanced by having this sort of this breakdown where if the first person to file a claim is incompetent, then that ends it for anyone else who is competent that could tell a court, hey, here's really what's going on.
Your Honor, to answer your first question, with respect to the sufficiency, in 2011, in Batiste versus SLM Corp., it stated that a complaint does not need to meet the heightened standard of Rule 9b in order to alert the government of a potential fraud. To answer your second question, the purpose of the False Claims Act is to encourage whistleblowers to disclose anytime there's a potential fraudulent scheme. And one of the mechanisms that they use to encourage whistleblowers is the fact that they would get to reap the benefits for a reward. They get 15 to 25% if the government intervenes. And if the government does not intervene, they get 25 to 30%. If this court were to rule that this rule is not jurisdictional and allow Mason's claims to move forward, it would discourage whistleblowers, because then, as you've mentioned earlier, anytime a later claim is brought with slightly more detail, that case will be allowed to take over as the first to file, as opposed to the original person who did indeed was the first to file. As in this case.
But Ms. Veloz, I think that Judge Davison mentioned this before. Based on what you've just said, okay, the complaint perhaps does not have to meet the 9b standard in order to be a sufficient filing. But if a claim is filed, it would still have to meet the plausibility standard, which is a lower standard. And so if you had a claim filed that did not meet the plausibility standard, you're saying that would still bar a subsequent filer as long as the object or the subject of that complaint was related to whatever was in the insufficient first filing. Does that seem, I mean, that doesn't seem right. That's not a legal standard, but isn't that kind of odd that the subsequent filer would be barred where the first person didn't put enough information forward to meet the plausibility standard?
Your Honor, this court has already explained that in order for a second case to be barred, it only has to have either there needs to be a pending case or it has to share the same essential facts. In this case, the False Claims Act is encouraging whistleblowers to put forth any information that they have to a potential fraudulent scheme. In this case, with Dr. Cobb's claim and Mason's claim, there is enough factual overlap that the two are indeed related. The Sixth Circuit in Poteet versus Metrotonic held that a later allegation is barred even if it incorporates somewhat different details or alleges more details. As long as it still stems from the same transaction, like the facts in this case, where Dr. Cobb's claim is alleging Medicare fraud and Mason's claim is alleging Medicare fraud, slightly with more details. In order to decide on whether a case is related, courts simply conduct a side-by-side comparison of the first filed case and the second filed case. And if the two complaints are related, courts must dismiss the second case.
So what if we decided on a narrow ruling and decided that in cases where the originating court found the first filed complaint legally insufficient, that there was actually no claim pending when the later action was filed?
Your Honor, this court was clear, and so is the Rule B5. Once a case is dismissed, another relator can bring their case. However, in this case, Dr. Cobb's complaint was still pending at the time that Mason filed her complaint. Even if this court were to interpret that the rule is not jurisdictional, Mason's complaint would still fail because the two cases are related. Petitioner urges this court to adopt the standard that they must share all of the same essential facts. However, the 15th Circuit, the 5th Circuit, and the 6th Circuit find that both claims do not need to share every single detail. They must simply be related. And in this,
Council, let me ask you another question. Why is our decision, our case not dispositive? This court said that whether Congress has clearly stated that the rule is jurisdictional, absent such a clear statement, courts treat the restrictions as non-jurisdictional. Is there anything you can cite where Congress clearly stated that the first to file rule is intended to be jurisdictional?
Your Honor, to answer your first question, Arbaugh shouldn't be the standard that this court adopts because the circumstance in that case is so factually different, being that it was a sexual harassment and Title VII case. In this case, which is a Medicare fraud allegation, this court should adopt this court's decision in California and Root Services, which states that in order for a claim to proceed, there must be no other pending action and it must not share the same essential facts.
But the nature of Arbaugh was, that was general language talking about how to interpret jurisdictional issues, through congressional, how to establish congressional intent regarding jurisdiction. So why does the nature of the action have anything to do with that?
Your Honor, even if we don't take into consideration the nature of the facts, this court in 2011 in Henderson versus Shinesky said, Congress need not use magic words in order to interpret a rule to be jurisdictional. Context, including the legislative history, is enough to let courts assume. Your Honor, I see my time has.
I'd like to hear the rest of your answer to my colleague's question.
Courts can look at the legislative history of how the rule has been applied. Since the rule's inception, 9 circuits have interpreted this rule to be jurisdictional. Therefore, this court should continue to presume that Congress intended the rule to be jurisdictional because it never amended it after that interpretation was applied.
Thank you.
Thank you, Your Honor.
Proceed, counsel.
Thank you. Chief Justice, and may it please the court. My name is Brian Hom, and I also represent respondent, Southern American Metropolitan Clinics Incorporated. The second issue before the court concerns the district court's correct application of an objective standard of falsity to dismiss Ms. Mason's claims. The 15th Circuit did not reach this issue as it correctly determined the False Claims Act is jurisdictional. Nonetheless, for the following reasons, we ask the court to affirm the district court's decision. First, the Acericare standard of objective falsity correctly determines that the reasonable differences in medical opinion between physicians interpreting medical documentation do not give rise to violations of the False Claims Act. Second, the objective standard of falsity, as put forth in Acericare, presents a clearer judicial standard and protects the judicial system from ill-placed complaints. Your Honor, to survive a motion to dismiss, a complaint must be plausible on its face and must bring forth sufficient factual allegations that nudge a claim across the line of conceivable to plausible. Additionally, the claim must raise some legal theory that is cognizable under the law, in this case, falsity. Ms. Mason has not exceeded this standard and has not raised allegations to create objective violations of the False Claims Act. There is no legal falsity here. Liability under the False Claims Act arises.
Counsel, how can you say there's no falsehood when Medicare has standards for what's eligible for hyperbaric oxygen treatments? And the allegations squarely state that those standards were not met in claims for reimbursements that were made by your client to Medicare.
Yes, Your Honor. You pointed out the objective qualifications for both the Wagner Grade 2 and Wagner Grade 3 and the CMS guidelines for hyperbaric oxygen therapy. And those are important here because there are no violations of hyperbaric oxygen therapy requirements for reimbursement set forth by CMS. Opposing counsel pointed to page 7 of the record, patients 1 through 4. Ms. Mason has asked the court to rely on her opinion of Wagner diagnoses and HBO prescriptions as objective evidence. Respondents' physicians willfully and knowingly committed fraud in front of the US government. However, patient 1 presented with type 1 diabetes with lower extremity ulcerated wounds. That patient was given a Wagner diagnosis of 2. However, shortly after a meeting with CEO O'Keefe, that patient was given a Wagner diagnosis of 3. The facts as alleged do not imply at all any false conduct on the part of the physician or on the part of the CEO. The only indication of falsity presented in Ms. Mason's allegations are her opinion that the conduct of those 2 individuals is suspicious. Patient 2 presented with also type 1 diabetes and osteomyelitis in the lower limbs. Ms. Mason alleges that because that individual was responding to a short course of treatment, that she was therefore ineligible for reimbursement by CMS. However, Your Honor, that patient 2, had chronic refractory osteomyelitis on her medical certification. That diagnosis in itself makes her eligible for HBO therapy. Patient 3 had end-stage vascular disease, was not diabetic, and indicated for amputation. Ms. Mason has not put forth the fact that under CMS's guidelines, as present in the National Coverage Determinations database, bullet point 5 of the 15 possible indicators for HBO therapy includes where an individual or a physician decides that a patient may suffer a loss of limb, life, or function of limb. In that instance,
I'm a lawyer, Judge. I never knew what HBO therapy was until this case. And while this case might be, it involves medicine, it could be a case that involves a nuclear regulatory authority, it could be a case that involves Army Corps of Engineers. How are we judges? Why would we put ourselves to such a high standard of objective falsity when we're looking at areas, maybe very sophisticated areas of science like that? We're not trained in it. Why would we, how would I know if something is objectively false? Isn't it enough just to say, I know what a pleading looks like that accurately lays the elements for fraud, but for me to go beyond that, at the reading the pleading, how do I have that expertise?
it is exactly because the court should respect the opinions of medical practitioners that the objective standard is the better standard. It couches the disagreement between medical practitioners into a standard that courts can safely use to evaluate disagreements of medical opinion. In AseraCare, the 11th Circuit and the District Court below recognized that putting 2 experts in front of a jury to simply duel about their reasonable understanding of a medical condition did not serve justice and in fact wasted judicial resources.
But that happens all the time, doesn't it?
Yes, Your Honor.
The experts duke it out in front of a jury all the time, and we judges instruct the jury and say, here's the law, you figure out who's more credible. We do that all the time, don't we?
Yes, Your Honor. The difference, however, is that in AseraCare, the experts admitted to both each other and the jury, the court, that they did not believe the other physician expert was wrong. They did not believe the other physician expert's certification to the government implied fraudulent conduct. They simply had different opinions. And that is what the objective standard seeks to keep out of the judicial system. It is also the way in which the judicial system can, as you mentioned, Your Honor, respect the intelligence and training of physicians that save lives every day. Going back to patient 4 on page 7 of the record, Your Honors, that patient also presented with type 1 diabetes and a lower extremity wound. Ms. Mason alleges that because she had none of the 3 indications osteitis, abscess, or osteomyelitis, that was a per se finding, could be a per se finding of fraudulent conduct, and therefore fraudulent submissions to the government. However, that individual also had a diagnosed Wagner 3 wound on her certification and record. It is also important to note that the record does not reflect the entirety of these patients' dossiers. Only Ms. Mason's summaries of what she believes these patients presented as. Furthermore, Ms. Mason is not allowed to diagnose Wagner grades in the state of Lincoln and is not allowed to prescribe HBO therapy. For her to put forth her opinion of the status of these patients as objective criteria within which this court is to judge fraudulent
But
conduct.
she has been in a jurisdiction where she did have the authority to make such diagnosis, right? So it was a little more than opinion, right?
No, Your Honor. The 4 patients provided on page 7 of the record are her opinion of why these patients are fraudulent submissions to the government. But as
But
indicated,
the grading scale, the Wagner grading scale spells out criteria that are pretty specific, right? So we can tell whether they're met or not. So couldn't she objectively determine whether or not the Wagner scale was met, criteria was met?
yes, Your
So
Honor.
that's a little more than an opinion, right?
Yes, Your Honor. She has, as well as anybody within the United States, has every ability to make those judgment calls. However, she has not presented any facts on the record that push this claim from the level of conceivable to plausible.
Well, as well as anybody in the United States seems a little bit extreme. Everybody in the United States doesn't have medical professional experience the way she did, right?
Your Honor, however, a False Claims Act may be submitted by any citizen within the United States, not simply a medical practitioner.
But you were stating her opinion. That's how we got to what we were talking about. You said it was just her opinion.
Yes, Your Honor, her opinion is the only thing that colors the facts on the record to imply falsity. In addition to these patients, Ms. Mason has put forth conversations that she overheard between CEO O'Keefe.
At common law, could a medical opinion be false?
No, Your Honor, not without more. To speak to that, Acericare in the 11th Circuit took the standard of common law falsity as parsed by this court in Omnicare Incorporated versus Laborers District Council Construction Industry Pension Fund, decided in 2015. There, in analyzing falsity, this court put forth 3 statements. The first, quote, that a sincere statement of pure opinion is not an untrue statement of material fact. Second, that an individual, quote, cannot state a claim by alleging that only an opinion is wrong. And lastly, that falsity turns upon whether a complaint calls into question the issuer's basis for offering the opinion. Now, opposing counsel has colored the interaction between CEO O'Keefe and Dr. Drake to attempt to imply that there is a fraudulent basis for offering these CMS certifications. However, on page 5 of the record, that conversation is merely a jovial conversation between a colleague.
Well, even if we take that one as jovial, we do have the allegation of altered diagnoses, correct? So that's a little more than the jovial, I've got enough money to buy a Tesla, right?
Yes, Your Honor. However, those allegations are also on their face, do not imply fraud. There were 2 allegations.
But Counselor, when we look at the quantum of the conversations that are set forth in the record, and the fact that certain action to alter the diagnosis and move these into a qualifying range that occurred after the conversations between the doctor and the CEO without any other medical intervention, can't that pattern be considered as a proper basis for substantiating, at least for purposes of the complaint, the fraud that's alleged by Ms. Mason?
No, Your Honor. That is
Why not?
Ms. Mason has not alleged any facts which indicate fraudulent conduct. Your Honor has referenced two separate conversations with Mr. O'Keefe and his physicians. The first in regard to patient 1 on page 7 of the record, where after diagnosing a Wagner grade of 2, the physician left to have a conversation with his manager and returned to change his diagnosis to a Wagner grade 3.
And the conversation that the CEO said, keep them coming, or something to that effect.
Yes, Your Honor, that is the conversation on page 5 of the record between CEO O'Keefe and Dr. Drake. And that was as characterized before, the jovial conversation where the CEO expressed his desire for his physicians to prescribe and treat their patients well, and the happiness that Dr. Drake felt in prescribing and treating his patients well. The fact that he can afford a Tesla or hopes to afford a Tesla because he is doing his job properly does not implicate fraud, Your Honor.
Counsel, I'm confused here. If you have a statute, the purpose of which is to ensure that, let's say, as it applies in this case, the healthcare organization is not defrauding the United States government, is it your position that only a physician can bring a complaint because only a physician is qualified to set forth facts that would, be able to be taken at face value? Here, as Justice Davidson said, you have someone who, at least at one point in her career, was qualified to make diagnoses. She has an impression. What is a person in her position to do to help bring this statute to its intended purpose? She can't go take those records and farm them out to a physician to get an opinion before she files. That wouldn't be okay under HIPAA. So how do we make the statute, what does the statute really require? Is it that only a physician can file a claim like this?
No, Your Honor, not only a physician can file a False Claims Act violation. And to answer your second question, all Ms. Mason had to do was allege facts that in and of themselves allege a violation of the NCD guidelines, the CMS guidelines, or the broad world of Medicare's guidelines.
And so under a TerraCare, what is the fact that she alleged an altered diagnosis and a scheme to pay doctors for grading patients to qualify? I want to finish it here.
Yeah.
Isn't that enough? Wouldn't a TerraCare say that's sufficient?
Yes, Your Honor, if Ms. Mason had alleged any actual fact which indicated that false or fraudulent conduct was present. However, because she does not reach a subjective standard, a common law standard, or objective falsity standard here. Thank you, Your Honor.
Thank you. Rebuttal?
Please, the court. 2 brief points on rebuttal, Your Honor. At her time before the court, Ms. Veloz argued that Kellogg is the proper standard under which to evaluate FCA claims. Your Honors, we agree. The problem is that Kellogg spoke to a factual scenario which is not covered in this case, that once a first filed claim is dismissed, a second may be brought. And so Kellogg is just not applicable here because Ms. Mason's claim was brought while Dr. Cobb's was still pending. So the question is, how do we decide which claims, how we should evaluate those claims and whether the first to file rule is jurisdictional? And Your Honors, it's under this court's clear statement and congressional intent rules that we must evaluate the first to file rule. And under those 2 canons of construction, the first to file rule is non-jurisdictional because it lacks a clear statement of jurisdiction, and because Congress did not include jurisdictional language in the first to file rule, while it did in other provisions of the FCA, means that it is a non-jurisdictional rule. Second, Justice Pierkorski, you asked Ms. Veloz, why isn't RBOW dispositive in this case? Your Honors, the correct answer is that it is. In RBOW, this court considered whether Title VII's requirement that a business must have at least 15 employers to qualify as an employer under the statute, and the court in this case held that that was a merits issue. That is, Arval's inability to show that her employer had 15 employees prevented her from bringing a meritorious claim. Your Honors, the first to file rule is also a merits rule because it speaks to who may bring a claim against whom and when, not the power of the courts to hear such claims. And so, Your Honors, the first to file rule is best understood as a merits rule rather than a jurisdictional rule, which means that, I see that my time is expired.
Thank you. Right, court will take this matter under advisement. Right here.
Congratulate both of you for making it this far and great arguments. And ask everyone to leave. The court.